brought you something. So you know that in addition to being an attorney, I actually have a baking business. It's called You've Been Served by Lily. Get it? You've been served.
Oh, that is good. That is good. Of course.
It's trademark right there. It's trademark right there.
Well, it's application's pending, but I'm almost done with that trademark. So hopefully that'll be finalized here pretty quick. So here is my secret recipe: lemon mini bundt cake. People have made offers for that recipe, and nobody's ever gonna have it.
we had no idea that this show was going to turn into a taste test, but Chris,
You need to try it.
is it that good, Chris? Speechless. What's up, listeners? This is F. Molina, and I got Chris Rodriguez with me. Chris, how are you doing?
Doing good, my guy. How about you?
I'm doing all right, bro. I'm doing so right that today we're going to talk about copyright.
That's so terrible.
Do you get it? Copyright?
Yeah, man, it's like dad joke number one.
Oh,
Go. Let's keep score.
And today we have with us an awesome guest. We have attorney Lydia Mount that does a lot of trademark law, copyright law, and we're here to ask her the tough questions about trademark and copyright law and see if she could answer like some of our questions, right, Chris?
I hope so. I have a lot of them.
How are you doing, Lydia?
I'm good. How are y'all?
Doing good.
Doing good.
Like, Lydia, so what made you want to do like copyright trademark law?
So I really like working with creatives. I think it's very important that people who do this kind of work, whether they're poets or authors or songwriters, movie makers, whatever work they're doing, I think they need to be credited for their work and compensated. And so I wanted to fill that niche here in South Texas. We have a lot of people who do creative work, and they need that kind of protection. We've got photographers, we've got graphic designers, we've got content creators, and all of those people need the protection that I can help them get.
Now, Chris, you're probably sitting here, and do you know what a copyright or what a trademark is?
I like to think so. I think it's a little C in the circle.
Can you explain to us what is a copyright and what is a trademark? Because I think what Chris was telling me is all you got to do is put like a little C like next to something and it's copyrighted. Is that?
So there's a little difference between trademark and copyright. So trademarks are it's a registered protection that you obtain for a good or a service that you provide. And the goods and services need to be provided through interstate commerce. So if you only provide the goods and service in the state in which you're doing business, you probably will not qualify for a federal trademark. You might qualify for state trademark, but that's what a trademark is for. It's to acknowledge or recognize the person or the company that is producing the goods or is providing the services so that they can be distinguished from other people who provide similar goods or similar services, so that people in the public know from whom they're purchasing the goods or from whom they are hiring the services, so they can make sure that it's the person that they want or the company that they want to do business with.
With copyright, what is that? We hear so many people say, I'm going to create this and I'm going to copyright it so no one steals it.
So the thing with copyrights is the copyright exists upon the moment that you create your work. So if you write a book, if you write an article, if you write an essay, a song, a poem, whatever, the moment you create it, your copyright is created. It's not registered with the government, but the copyright is created. Now, some people might say, well, why would I want to register it if it's created upon my creating the work? Well, because if you create it and then register it with the federal government, it gives you greater protection in the event you want to file suit for somebody using your work without your permission.
So filing it in like the copyright like office is far better than just adding the little C next to it saying it's copyrighted.
Yes, and so people who want to add the little C, giving the impression that it's a registered copyright, might be accused of fraud. If you add the R for trademark and you don't actually have a registered trademark, could also be facing fraud charges because you're presenting it as if it's registered when it in fact is not.
When it's not. I wrote a manual for a company, let's call it 10 years ago, 15 years ago. And this manual was used to the entire company. This company is really big. It's nationwide. And all the companies using this book now. They had offered me money then. They had offered me positions, everything, so I can give them the book that I wrote for the manual. But I said I don't want it. I wanted to keep it. Now, come to find out now that they kept a copy of it and they're actually using it throughout the whole company.
Let me give you my business card.
Okay. I mean, the best answer.
So if Chris creates a book, right? if anyone creates a book, do they own that creation?
Well, it depends. A lot of employers include in their employment contract with their employees that any work produced while they're an employee of that company, it belongs to the company. So it's called work for hire. And they're paying you. It's part of your job. The end product belongs to them.
Interesting. Okay.
So I don't know what the circumstances are around your particular situation. That might be the defense that they would use, but it might not be if they were offering you money to purchase it from you. So things to consider. But so when people create, if they were hired to create it and it's in writing, then it becomes the person's who's purchasing the work. For example, let's say you hire a photographer to take your family photos or your engagement photos or whatever. To whom did the photos belong?
I'm gonna say
I think the photographer,
why would the photographer?
because he took them on his camera. No.
But all he does is press a button, though. Why is he gonna own? He shouldn't be able to own anything. I mean, who's right, Lydia?
Okay, so they belong to the photographer. It's his work. The only way they belong to the people who paid for the photography session is if they worked that into the contract, the agreement. Now, why is that important to know? Because a lot of photographers, especially here, I have learned in our area, don't use contract, and so a lot of their sessions are basically just word of mouth referrals. But the actual agreement with the people is also word. It's just their word, whatever
It's
they
just
agree
a handshake.
to. Yeah. Right. And so what photographers can do is they can enter into an agreement through a contract, a services contract, that indicates that they are keeping all the rights to the photos and they're only allowing them to purchase images, or they can license them to use the photographs in certain ways, or they can completely convey or transfer all their interest in the photos to the people who hired them to take the photograph. But many people don't use contracts.
I'm sure a lot of people don't even know about that.
Yeah, I mean,
seriously,
Photographs belong to the photographer unless there's an agreement otherwise.
So does that also apply? Because everyone has a camera on their cell phone now. So if you take a picture,
It's your pick.
I mean, that it belongs to you.
That's right.
Wow. And what is this? What have you seen with social media? Because social media is so content creative, driven. They're taking pictures on their phones. They're creating their own audio. What have you seen, or what would be your recommendations to these content creators?
I think content creators should give me a call, because I also have contracts for content creators, because they need to also set expectations just like photographers do with regard to what is theirs and what they are going to transfer as far as licensing or contract for the photographs and the content that they create. When it comes to photographs on social media, a lot of people think that it's perfectly okay to take somebody else's photograph and then retweet it or repost it on Instagram or share it in some way, shape, or form. And we have found that, and we're seeing all the time now in the news and in on social media outlet, how it's not the case, and celebrities are being hit with lawsuits left and right. Some of them more than once, because they don't learn. For example, Dua Lipa has been in trouble twice now because she shares a photograph that someone took of her. And I'm thinking maybe she just figures it's a really nice photograph and she wants to share it with her followers. But if you don't have the permission from the photographer who took the photograph, you're not permitted to do so. So we've seen a lot of that happen.
So let's say somebody gets a photograph, right? And they alter it. They turn it into a meme. So prime example is I put up a photograph during the whole lockdown pandemic thing, and it was a picture of a baseball bat coming, hitting a whole bunch of crowd, the whole crowd, everybody's doing this number, and there's a little girl, and it's the world's burning. This is me thinking of what watch I'm going to buy, and you see a little girl just really pensive. But I made that into a meme. The owner of that photograph contacted, and he said he's like, this is my picture. I took it. How'd you get it? I'm like, well, it's all over the web.
All over the internet, right?
Yeah, it's something that gone viral already. In that situation, does he have something against me? Can he do something, or being that I altered it?
Well, it depends how it was altered. So under the copyright law of the United States, there's an exception that's drawn for what we call the fair use exception. So if somebody were to take a work and they want to alter it and use it as their own, they might be able to do so based on 4 different factors. And when I say they might be able to do so, I mean you're now in court and you're trying to get the court to decide in your favor that you fall under the fair use exception. So one of the things that you have to look at is, why did you use it? Were you using it for educational purposes, or were you using it for monetary purposes? Were you trying to gain some sort of financial benefit from using it? One of the other things you have to look at is, was this work a creative work, or was it more of a technical? So it might be different. It might be viewed differently by the court if it was a song or a photograph, as opposed to an instruction manual for how to change a tire. So two very different kinds of works.
Yeah.
The other thing is, how much of it did you use? Did you use just a portion of it, or did you use the whole thing? For example, did somebody, I don't know, perform a play from Broadway and use the entire play? Or did somebody...
Well, who would do something like that?
I don't know, somebody who didn't check with their intellectual property attorney.
Someone who did not hire Lydia Mount.
So you want to look and see how much of it you actually use. So did you use the entire play, or did you just use like maybe a line from the play that would be very well known, or very easily recognized, like Romeo, Romeo, wherefore art thou Romeo? So you use that one thing, but maybe you used it for educational purposes. You didn't use it to make money off of it. So what kind was it? Is it creative, or is it more technical? 2, how much of it did you use, and how much of it did you change? 3, did you use it for money?
For the record, I did it for likes.
No.
likes.
Anyone that knows you, Chris, knows there's always some type of financial incentive for you. You're not fooling anybody.
These are lies.
Okay, so the fourth part is, what effect is it going to have on the market that's available for the original work? So I don't know. I think a lot of times, if a person reaches out, probably the smartest thing to do is stop using it, because the next thing is going to be C&D, cease and desist. And those usually lead to loss if they're not.
And what are some of the like penalties for copyright? Because I mean, one of our like heroes, well, bless our heart, George Lucas, he used to be like one of the like most heinous copyright enforcers like ever. Like if you made Star Wars costumes, or if you sold like anything with Star Wars related, you would get one of those cease and
desist.
So what type of penalties are people looking at?
I think a lot of it's based on how much you made off. So for example, trademark law here in Texas, under Texas common law, just Texas common law, let's say you don't even have a trademark registered with the federal government. In Texas, a person can receive up to 3 times the net profit that the person who used it without permission made during the time that they were your mark. So if somebody were to use, say if you have a trademark, or it's not registered, but it's your mark and everybody knows that that's you, and somebody else has been using it for the last year, then their net profit from the last year, multiply it times 3, that's how much you could get.
Wow.
Holy smokes.
Yeah.
So like,
it's a big deal.
when you say that, it reminds me of that scene from Coming to America, where you have McDonald's and then you have McDowell's, right? So if McDowell's was like really like operating, like 3 times his profits can be taken away and given to McDonald's if he was here, like in Texas.
Yes.
Wow.
So yeah,
Wow,
and
that's stiff.
there's I work with people on both sides of the situation. I send cease and desist letters, and I also respond to cease letters for different clients. And there's a huge problem with here in the Valley, actually it's everywhere across the country, but I've seen it a lot recently here, where people are selling goods that are trademarked, and they're luxury trademark. You've got huge companies who send people out to do nothing but be mystery shoppers to see who's using their brand on goods that aren't real. They're not, by real I mean they're not made by that company, but
like
they've got their logo on it.
Yeah.
And some people try and argue, well, it's art because it's not really their work. We drew their logo on something, and we're not pretending to be them. It doesn't make any difference. They're gonna come get you, and they're coming after.
So even if you're selling these knockoffs at the same place they sell like Speedy Papas, they can still get into trouble?
Oh yeah, you can still get into trouble big time. And they know where people are. They've got investigators all over the place.
Wow.
Yeah.
And what about words? Like there's a lot of social media like influencers that create these words, and they're like, that's now my word and no one can use it. Like, that they make up. which ones have I seen that people just use like crazy, and everyone's claiming to be the owner. It's
so Cardi B, I want to say she attempted to get Okurt trademark.
Oh, okay, yeah.
She tried to get
Yeah,
Okurt,
yeah.
but I don't think, Okurt. I'm not going to do the
Do
R
it,
because
it's
I think
okay.
it's just going to sound
It's
funny.
great.
But I like you doing it. I thought that sounded
yeah.
pretty good.
I thought we were gonna have like pure gold right now.
Yeah, I'm like,
I was like,
yes.
So no, but I believe she attempted to get that word trademarked, and then it became a matter of, well, no, whose was it first, and was it really hers, and when did she start using it, or did somebody else start using it, or is it so commonplace that it can't be trademarked? Because you can't trademark just anything. It has to be something that's original, something distinct. Otherwise, if it's commonplace, like you can't trademark the word tree.
I mean, one can argue that you can trademark like faux shizzle, Snoop
Maybe.
Dogg. I mean, that is
He
like
might.
straight up Snoop Dogg.
That is his. He probably could. If it's not already, I mean, we probably should look that up.
I mean, that'd
and
be cool,
see if
right?
It is.
Like-
Yeah.
yeah.
Faux shizzle like
Faux shizzle.
Snoop Dogg.
Well, stop saying that word, Chris, because if it is copyrighted, this is coming down from Facebook, or we'll get a cease and desist letter from Snoop
Or
Dogg.
know
maybe
a lawyer,
not
man.
because he credited him. He's not trying to claim it as his. So we can just say thank you, Snoop, for allowing us to use the word in this podcast. But it's yours, and we all know it's yours.
We all know it's
Everybody
yours.
knows it's yours.
Jurgonaut knows. F knows. We all know.
Everybody
We all know.
Everybody knows
Everyone
it's
knows.
Snoop's. Nobody wants to mess with Snoop.
No.
And what's the there's so many catchphrases that people use. What makes a certain phrase that makes you think, okay, this might be a trademark, or this might be like a copyright like type of phrase? What?
So if somebody wants to trademark their tagline or something that they believe sets them apart from somebody else, they have to first apply, but they have to see whether or not it actually falls under the qualifications for a registered trademark. Primarily, is it used in interstate commerce? You got to ask and answer that question. But also, you have to look and see, is it really original? Is it so original that you can separate yourself from everybody else? And then you have to, when you make your application, you have to explain the purpose of that word or that phrase or that logo, that design, and file your application within a certain class. So you can have the same word trademarked multiple times, but in different classes, and the mark could be owned by different people. For example, think of American Airlines. Okay, so they have it trademarked under certain classes, but you also have American, which provide or sells a product. They make toilets and sinks and bathtub.
That's right, yeah.
So they have it, but under a different category. So you can have the same word trademarked in different categories, but you have to be able to distinguish why it's in that class and not in another class. And then when you make your application, you send it off to the United States Patent and Trademark Office, and they evaluate it and determine whether or not there's any likelihood of confusion between your mark and somebody else. So they're going to look and see if you're going to confuse the consumer in any way and make them think that you're really this other provider and not yourself. And some people think, well, I should be able to do Starbucks if I don't spell it with a CKS, but if I spell it with, 2 Ks and an S, the likelihood of confusion is still there. Even if it's not identical, if it's similar enough that it's going to create confusion, they're not going to let it fly.
Then it's a problem.
Yeah, it's a problem.
They're not going to approve it. But you don't have to just trademark words or phrases or pictures or logos. You can also trademark scents, colors, shape.
What?
Yeah. Did you know that the red
No.
the red on the bottom of the Christian Louboutin shoes?
Yeah.
The red bottoms?
Red
that red is trademarked.
What? Well,
Whoa.
actually, yeah, no, yeah, like the Tiffany blue.
The Tiffany blue is also trademarked.
Yeah.
Yes, it is. Did you know that the green and yellow on John Deere trademarked?
That's trademark too.
Mm-hmm. The brown and gold on the UPS, one of my favorite delivery places ever. Thank you, Amazon. Yeah, that's also trademarked. I don't know how old y'all are, but do y'all remember what color insulation is inside of a home? Pink?
Yeah,
pink.
Yeah.
I don't know if you remember the ads. There was a Pink Panther.
Yeah, the Pink Panther, yeah.
So the pink, trademark.
That's
Yeah.
crazy.
But you also can trademark shapes. The Coca-Cola bottle, the Hershey
yeah.
Kiss.
Yeah, that's crazy. Yeah.
Yeah.
That's nuts.
And you can trademark scent as well. Perfumes, different things.
That makes sense.
Yeah.
That makes sense.
I've heard, and I don't know this for sure, I need to go look it up, but I've heard that the scent in Abercrombie and Fitch, what you smell when you walk into their, when you walk into their stores, that scent is trademarked.
Unfortunately, Lydia, me and Chris were not the Abercrombie type of males.
I couldn't walk in there.
I didn't walk in there either. I walked past it on my way to Sephora.
Oh, she's one of us, Chris. She's one of us.
Yes, that's good.
Yeah, we weren't the cool kids.
No, not at all. No, I was buying Huskies at Sears. So
no, you shopped at Gadzooks. If people remember what that was, Gadzook. The other thing, Lydia, is if you could solve a debate between
I hope you're going right.
me and Chris.
Oh no.
So Chris likes to post music videos on his Facebook account, and when he posts these music videos, he says, he has a caption, "I do not own the rights to this music," believing in some way, like hundreds of other people, that by saying "I do not own the rights to this music," it somehow protects you from any type of copyright violation.
But
is that true?
But miraculously, it never gets flagged.
So I mean, Facebook can do a lot to you, but the owners of the songs can do worse.
Lizzo's gonna be pissed.
Yes, I wouldn't mess with Lizzo.
I love her, man.
I love her too. She's from Houston. She could hurt you.
No joke. Her song's my ringtone.
I love her. I love her
Lizzo.
Music. I love her attitude. I love her. Love her. Love Lizzo.
She's awesome.
Lizzo, we love you.
Yes.
Nobody here wants to cause any damage to Lizzo.
No, I love
we would
Lizzo.
definitely come to her defense. No, a lot of people think that by putting up that disclaimer that they're saving themselves, but you're not. I mean, if it's a song that is available for you to post, because social media sites allow certain music to come up, and I think they treat your account differently if it's a business account. Like Instagram will treat you differently if it's a business account or if it's a personal account with regard to what music you can attach to a reel or a post of whatever sort.
And speaking of music, Lydia, there's a lot of musical artists down here that create just these really good songs. I mean, we got a good musical community down here.
Very talented people here.
Mm-hmm.
What about their songs, their creations? What can they do to protect themselves with these works that they create? And then they try to get views out there, so they put their songs on Facebook, all these other apps, and there's always a potential of someone stealing them.
Well, my advice is copyright it, because even though the copyright is in existence at the moment that the work is created, if they don't have that federal protection of actually having a registered copyright, it's going to be a much more difficult task for them to protect their work. And so they need that protection, because that way, if somebody decides, you know what, we really like this group or we really like this artist and maybe we want to sign them or maybe we want to play their music on our airwaves, then they need to have that so that they can always make sure that everybody involved in that transaction know this is mine. Mm-hmm. Not yours, but mine, and I created it. And if you want to license it, there's going to be a price for you to pay, because all creative should be credited and compensated. Those are the two things. All creative people should be credited and compensated.
100%. There's a myth with musicians here in the Valley. I don't know if it's all over the place or just here in the Valley, but lyrics. So they write lyrics, and I used to have a metal venue back in the day, and they would say in order to copyright their lyrics, they would mail it to themselves.
Okay, so I understand that, and I've heard of it, and it has no value.
At all? Really? That's crazy.
It's called a poor man's copyright.
Oh, sorry, guys.
It's called a poor man's copyright, and it's got no effect.
The poor guys. Okay.
No, they should register it. Like I said, the copyright exists from the moment they create it, but it's going to be really a lot harder to enforce a copyright if you don't have a federally registered copyright.
Okay, so if a musician, artist is listening to this podcast, they're like, I got to go see Lydia Mount to copyright my stuff, right? What should they bring when they call you and say, we're going to have a meeting? What should I bring to Lydia Mount to have her assess my stuff?
Well, so I would like to see a list of their works and how it's being collected together. Is it one song? Is it a group of songs? Is it an album? Has it ever been published? Is it not a published work yet? Has nobody heard it? Have they been playing it? I mean, I would have a multitude of questions. I would like to know when they wrote it, if they were inspired by anybody or if it's completely and totally 100% theirs and they didn't use any lyrics or any inspiration that would be obvious in their lyric, because
Vanilla Ice.
That's totally Queen. Yeah.
you don't want to borrow. I think what they call it is
Sampling.
Sampling. You don't want to sample. I mean, if it's legally done, great. If the artist will let you do it, but if it's not,
Yeah, you run the way of like Puff Daddy. Like Puff Daddy, when he wrote that song, like I'll Be Missing You, he never got the permission from Sting. So all of the profits now from I'll Be Missing You, although it's written for Biggie Smalls, Sting gets all that money. It's crazy. It's crazy how all you had to do was contact Lydia Mount, get your copyright and get the permission, get the royalties lined up, and you would have no problems.
I would have taken his call. Puff, Daddy. I don't know. What are we calling him?
Sean Puffy Jones.
Sean Puff, whatever. Ex Mr. J-Lo. I would have taken your call.
Sean Puffy Combs. Yeah.
I grew up, my mom and dad taught us your name is everything, and you have to protect your name, because without people knowing that, you're a good person and that you're going to do the right thing, what do you have? And so my name and my work, those are very, very important to me. And I'm going to protect my name and I'm going to protect my work. I'm going to protect my brand, because that's how people recognize me. And I think everybody should protect their name, their reputation, their brand, and not let other people abuse them by using it without permission. And there might be a cost up front for doing it, for your songs, for copywriting your book, your poem, registering your trademark or your service mark, your logo, your tagline, your color, your shape, your scent, whatever. But you have to think long term. Don't think just immediately. Think about, in the end, how much protecting your brand is going to benefit you. And if it's a big enough brand and your business gets to be big enough, could be the legacy you leave your children.
Yeah.
Thank you, Lydia.
You're welcome.
Thank you so much.
Thanks for having me.
Yeah.